next thing I know, these two officers were in the house. Their version of the story was that they had found us engaging in sex. They just yelled, threw me back on the couch. It's just all of a sudden, we're taking you downtown. I wasn't allowed to put clothes on. I was handcuffed and dragged downstairs.
The states had banned so-called sodomy, which included certain specified sexual acts over many, many years.
Where we were charged with 2106.
Laws similar to the one in Texas made sodomy a crime in 12 other states. While laws like these may seem trivial and unlikely to be enforced, they provided an avenue for discrimination against same-sex couples.
The problem that the litigants had was that the police weren't using this law to arrest people in the privacy of their home, and judges were requiring that that happen before you could challenge the law, and yet, the law was having an effect throughout society.
We got right to the point where they were going to start talking about placing a child with us, and the social service agency we were working with came to us and said, we can't place children with criminals.
The folks in Richmond sent a letter to Lutheran Social Services, the social service agency we were working with, that basically said to Lutheran Social Services, if you keep sending prospective parents to us who are criminals, we will pull your license to practice social work in the Commonwealth of Virginia. And they attached a copy of the sodomy law and the cohabitation law.
No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. This last clause is known as the Equal Protection Clause. It clearly states that laws must not treat one individual differently than another under the same circumstances. Laws like Texas's 2106 only criminalize sodomy in same-sex relationships, but not opposite-sex relationships, thereby violating the clause. They held America back from advancing in the gay rights movement. Lambda Legal, a renowned law firm that specializes in LGBTQ cases, heard of Lawrence and Garner's arrest and saw it as a big opportunity. While it was easy to see the detrimental effects of sodomy laws, very few arrests actually ever happened. A case cannot be brought to the courts unless the petitioner has been injured. In 1986, the Supreme Court case Bowers v. Hardwick called a similar law in Georgia into question. The court's decision upheld the constitutionality of sodomy laws. LGBTQ activists had to wait for the perspective of America to change, as well as a clear example of the enforcement of sodomy laws, to bring the case back into the Supreme Court. Lambda Legal passed the case through a series of lower courts before reaching the Supreme Court. When they finally did, they had three certiorari asking the court to consider whether the petitioner's criminal convictions under the Texas homosexual conduct law, which criminalizes intimacy by same-sex couples but not identical behavior by different-sex couples, violate the 14th Amendment guarantee of equal protection of the laws. Whether the petitioner's criminal convictions for adult consensual sexual intimacy in their home violate their vital interests in liberty and privacy protected by the Due Process Clause of the 14th Amendment. Whether Bowers v. Hardwick should be overruled. The fundamental constitutional violation of sodomy laws was its incompatibility with the Equal Protection Clause. The laws allowed for blatant discrimination that other citizens would have been protected from.
Someone wanted to discriminate against somebody because they're gay or lesbian, they had an avenue to do it.
The sodomy law had to do with the fact that I couldn't adopt a little boy who needed a forever home.
The opinion of the court number 02102, Lawrence against Texas, will be announced by Justice Kennedy.
The question before the court is the validity of a Texas statute making it a crime for two persons of the same sex to engage in certain intimate sexual conduct. We conclude the rationale of Bowers does not withstand careful analysis. Bowers was not correct when it was decided, and it is not correct today. It ought not to remain binding precedent. Bowers v. Hardwick should be, and now is, overruled. The petitioners are entitled to respect for their private lives. The state cannot demean their existence or control their destiny by making their private sexual conduct a crime. Their right to liberty, under the Due Process Clause, gives them the full right to engage in their conduct without intervention of the government. It is the promise of the Constitution that there is a realm of personal liberty which the government may not enter.
My dissenting opinion responds to the particular legal points made by the court that certain forms of sexual behavior are, as the court says, quote, immoral and unacceptable. That is the same interest furthered by criminal laws against fornication, bigamy, adultery, adult incest, bestiality, and obscenity. For many Americans do not want persons who openly engage in homosexual conduct to be partners in their business, scoutmasters for their children, teachers in their children's schools, or boarders in their home. They view this as protecting themselves and their families against a lifestyle they believe to be immoral and destructive.
Despite a scathing opposition, there is no question that Lawrence versus Texas completely revolutionized the gay rights movement for the better. It made it easier for closeted members of the LGBTQ community to come out, which consequently made it harder for homophobia to thrive.
I came out of bed quite happy.
20 years ago, lots and lots of people in the United States could say, I don't know any homosexuals. And I don't think there are very many people today who could say that.
Yeah.
Because, I think that's the biggest difference. And I think it's an incarnational difference that it's easy for people to say, I hate homosexuality. It's hard for them to look at somebody they love and say, I hate you because you're a homosexual.
The argument against gay rights became largely invalidated. The topic became more about personal opinion, such as religious belief or ethical perspective, and less about the black and white, purely legal interpretation of homosexual behavior. People couldn't say they didn't support the gay community because of their illegal activity. They could only say they didn't support them because it didn't feel right, or because the Bible said they were sinners. Time magazine called Lawrence versus Texas the Supreme Court's most sweeping gay rights decision ever. In his dissent, Scalia outlined his biggest fear regarding the court's decision, that it might mean more victories for the gay rights movement in the future.
The people may feel, for example, that their disapproval of homosexual conduct is strong enough to disallow homosexual marriage, but not strong enough to criminalize private homosexual acts. And they can legislate accordingly.
Scalia's narrow-minded apprehension turned out to be an accurate prediction. On November 18, 2003, it became clear that Lawrence versus Texas had successfully brought America a step closer to the legalization of gay marriage. Just 5 months after Scalia delivered his dissenting opinion on this case, the Massachusetts Supreme Judicial Court legalized gay marriage, making the state the first to do so in America. Chief Justice Margaret Marshall even quoted the Lawrence decision in her majority opinion, saying, "Our obligation is to define the liberty of all, not to mandate our own moral code." Today, gay marriage is legal in 19 states and Washington, D.C. In 1999, a year after Garner and Lawrence's arrest, a Gallup poll showed that only 37% of Americans supported gay marriage. As of May 22, 2014, Gallup polls show that a record-breaking 55% of Americans are for marriage equality. The gay rights movement in America is one of the fastest human rights movements in history. If it weren't for the rare arrest of John Lawrence and Tyrone Garner, or Lambda Legal's devotion, America might not have been where it is today.
When you're singing that song